All right. Well, hello, everyone. I know that our attendees are just rolling in. Uh, if you are just joining us, this is day 2 of Will's Week, the inaugural University System of Maryland's celebration of National Estate Planning Awareness Week. If you're joining us from yesterday, I know we had a wonderful presentation. We will be sending out all of the recordings at the end of the week, and if the presenters wish to share their slides, they will also be available in PDF form at that point. So watch for that email. There'll also be a survey in there as well. Just a little bit of housekeeping before we get underway. If you want to throw into the chat while we're getting started, and I did turn the chat on today, so if you have any issues with that, that is still on me, and I will fix it because I know how to do that. Um, so if you just want to put your name, where you're watching from, maybe which campus you're with or which town you are, and then most importantly, you can just put a yes or no. Do you have any estate plans in place already? And if you don't, that's why we're here, and you're in good company because sadly, about 2/3 of Americans do not have estate plans in place. So we are here to try and remedy that situation. Um, and we hope that by the end of the week, you will feel much more comfortable with the process and confident in getting your own plans done. My name is Ann Kolakowski. I am the Director of Gift Planning Services for the University System of Maryland, and I'm happy to have some of my system colleagues helping behind the scenes today. We have Missy Ham-Cross and Liz Connors from University of Maryland, Baltimore, and Nicole Hand from University of Maryland, College Park. They will be sort of keep an eye on chat and the Q&A. And as a reminder, please, if you have a question, put it in the the Q&A, because the chat gets a little crazy and we can't keep an eye on it. So again, we are delighted to have you with us, and it's my pleasure now to introduce today's presenter, Chris Walter, who leads Davis, Agnor, Rapaport, and Skalny's estate planning practice group with a blend of expertise and strategic planning. He focuses his practice on estate planning to help his clients prepare for the unexpected, and estate administration to help make sure a loved one's wishes are carried out. He's also skilled in the specialized intersection of estate planning, business succession planning, and income tax planning required to help business owners preserve their legacies. Prior to his current role, Chris spent 6 years at a boutique estates and trust firm in Baltimore County. And fun fact, that is where I met Chris first. It was probably 12 years ago, because he helped my husband and I put our estate plan in place. So the total coincidence. It's fun to see him again. He received his BA from the University of Maryland, College Park, and his JD from the University of Maryland, Francis King Carey School of Law. So I'm going to turn my camera off and turn things over to you, Chris. Thanks and welcome.
Thanks so much, Anne. Appreciate the intro and nice to be speaking with all of you. I'm going to go ahead and share my screen. So before I was in the role I'm in now, and as a lawyer, I was actually working with the University System of Maryland in various roles, first at College Park, then at the law school in their gift planning and major giving departments. So it's nice to see and be communicating with some old colleagues again. The focus of this presentation is getting it right the first time: special estate planning considerations for young professionals and families. We are going to start the presentation going through some estate planning basics. What is estate planning? It's going to be some of what was covered yesterday, but good reinforcement. And for the people who weren't able to join yesterday, it's going to be just an overview of what we're doing when we're talking about estate planning. We're going to go into how I make an estate plan, the different avenues to that, and then we're going to go to things to focus on or things to think about as a young professional or a young family or somebody first, doing a will or doing an estate plan for the first time. So what is estate planning? It's really broken into two categories for me. It's planning for disability and planning for death. When we're planning for disability, we're normally dealing with powers of attorney, medical directives, and if you don't have those in place, or sometimes if you do, you have to go through the guardianship process. Planning for death, that's often making a will, and that's what people most often associate with estate planning, creating a revocable trust. Sometimes there's other trust involved, but for basic estate plans, it would normally be a revocable trust. And then importantly, paying attention to beneficiary designations and asset titling. So I'm going to start talking about planning for disability, then move on to planning for death. Planning for disability, sort of the basic question is who can make decisions on somebody else's behalf? Uh, there are two types of decisions. There's legal and financial decisions, and then there's personal healthcare decisions. Well, for a disabled person, a guardian of the property and or person, an agent under a medical directive, or an attorney in fact under a power of attorney. Nobody else is legally authorized to make decisions for you. I know it's common for, I've got a kid turning 18 and geez, less than a month now. And on his 18th birthday, he's going to get a power of attorney and medical directive to sign. He knows this just because at that point, his mother and I no longer have the legal authority to do all the parenting things that we do in the normal course. So important considerations there. When we're talking about planning for disability, we are doing it so we're changing the defaults. The guardianship defaults are who the court picks as your guardian. And there's a priority list and you have to petition, but you might have different people on the same level. So you get to choose who you want to make decisions instead of having the court make that decision for you. Guardianship is expensive, it's intrusive, it's court supervised, and it's just a hassle to deal with. And you're trying to minimize uncertainty and family stress. So those are some of our objectives when we're planning for disability. Guardianship can only happen after somebody becomes disabled. So it's not something you can plan. It's really there for lack of a plan. It requires oftentimes attorneys, court filings, hearings, physicians get involved. You have to do an accounting to the court for guardianship of the property. It's just a real pain, and you can avoid doing all this with a power of attorney or a medical directive. So I'm going to start with medical directives. As the name suggests, this is for making medical decisions on somebody else's behalf. And it is there to authorize somebody to make healthcare decisions for you. You're expressing wishes about end-of-life care. It also, we used to include, just as a practice, a lot of attorneys used to include funeral arrangements and wills. Funny thing about that, oftentimes the will's not broken out until after it's too late to make funeral arrangements. So oftentimes that's now held in a medical directive instead of in a will, or it's held in both and they mirror each other. And go back. So there's guardianship of the person, there's guardianship of the property. Guardianship of the person deals with your sort of autonomous human decisions, your healthcare, et cetera. Guardianship of the property deals with managing finances. Medical directives can avoid guardianship of the person. A medical directive has three parts. Part A is where you name your agents and you give them their authorities. So you're saying that this is the person, or these are the people, or these are the people in sequence. You can name a primary and a backup and a third backup, fourth backup on down the line. These are the people that, if I can't make my own decisions, can step in and make those medical decisions for me. They can do things like coordinate with doctors, discharge you from, hire fire doctors, check you in and out of facilities, ride in the ambulance, etc. Part B is what you may have heard referred to as the living will before. It's where you're giving your instructions on what should happen essentially if you have a condition where the only thing keeping you alive is life support and you can't make your own decisions. So that's a terminal condition, a persistent vegetative state or an end-stage condition, and there's no reasonable hope for recovery. Oftentimes, we'll have the pull the plug discussion when we're talking with clients about this section, but it's a lot of considerations about, okay, do I want my agent to have the authority to override what's in black and white? Um, if there's special circumstances, these are the things that go into Part B when you're crafting this document with your attorney. And then Part C talks about organ donation, funeral arrangements, memorial arrangements. Some people just say, hey, whatever my person says goes. Some people get very detailed in this section. It's mainly an authorization, but sometimes it does contain directions too. This document, the most or medical orders for life-sustaining treatment, it often accompanies a medical directive. It's not something you prepare with a lawyer. It's something that you prepare with a physician. People often bring it to us and we'll keep a copy in our file to go along with their medical directive. And sort of boots on the ground, practical reality, even though a medical directive takes legal precedence, this is what the EMTs are looking for if they pick somebody up. For most young professionals, this is not a big consideration. I don't have the most, and it's not needed for a lot of people. You might have heard this referred to as a DNR, do not resuscitate. If something were to happen to me, I'd want to be resuscitated. But if somebody has a diagnosis, a prognosis, they're aging, they might have a MOLST that they fill out with their doctor, and we encourage people to make sure that the MOLST and the medical directive say the same thing. So that's a quick overview of medical directives. Powers of attorney, sort of switching modes. This is for legal and financial decisions instead of for healthcare decisions. So power of attorney, it's you're the principal if you're making it, and you're authorizing your agent to make those decisions for you. Instead of avoiding guardianship of the person, this avoids guardianship of the property. And sorry, I'll go back a second. So we and most attorneys base this off the Maryland statutory form. There's a provision in the code that says, hey, if you use this form and a bank tries to reject it, then your agent can sue to enforce that power of attorney, and then the bank's got to pay attorney's fees and the cost of litigation. So it's got some teeth to it. I have not had any issues getting the statutory form power of attorney accepted. Where older powers of attorney, where every firm had their own thing, that can be harder to implement. So oftentimes powers of attorney, they're supplemented with important provisions that us lawyers feel we need to throw in there. But the first, couple pages of it are all uniform. And it essentially says that I trust these people to do anything for me of a legal or financial nature that I could do for myself. Oh, and I went the wrong way because I know which way buttons go. So sort of a quick who does what. Medical directive, you make medical decisions for the declarant, access medical information, and you enforce their wishes. And then for a power of attorney, you're stepping into the principal's shoes to open accounts, to sue people, to file taxes, to do anything that they could do for themselves, except for write a will. So that covers the planning for disability. Planning for death, want to talk about the objectives here before we go into the nitty-gritty. So for the objectives, you're providing for spouse, family, loved ones, charities, friends, etc. You are, again, the state's got defaults for what happens if you don't have any plan in place. You are superseding those defaults and saying, this is what I want to have happen. You are potentially setting up trust for beneficiaries. You can choose how property passes from you to somebody else, so you can dictate how stuff's managed, protect it from a young beneficiary who's can't, too young or immature to inherit, deal with special needs beneficiaries, etc. There's some tax optimization that can be done. And then when we're doing this, we're trying to make this as streamlined a process as possible, given your facts and circumstances. So before we talk about what you do to plan for death, it's probably useful to talk about how property actually passes at death. I'm going to break it into four different categories. Uh, First, first dealing with the non-probate property, jointly owned property. So if me and a spouse owned a house together and I died, it would be the spouse's, as long as it's titled as, joint tenants or tenants by the entireties. It just passes automatically by virtue of law. Beneficiary designated property, that's the certain contract property. That's like beneficiary designations on an IRA or 401k or TSP or your life insurance policies. What that says goes, and it doesn't matter what you say in the will or any other document. And there's trusts. If something's owned in a trust, what the trust says goes. And then there's everything else. I'm going to put aside the life estates for a minute. But everything else is property that's owned in your sole name at the time of your death with no beneficiary form associated with it. That's what goes through your will and through the probate process. And if you don't have a will, that's what goes through intestacy. Right? So what is a will and why do you need one? Start talking about what goes into a will. We have some administrative provisions, so things like an authorization to pay funeral expenses without getting the court's permission if it goes over a certain limit. Yeah, different provisions about taxes, digital assets, things like that. It directs what happens to your probate assets after death, though, and that's sort of the main thrust and what people think of when you talk about what a will is or what it does. Like I was mentioning earlier, it can establish trusts for beneficiaries. So the will can say, when I pass, instead of giving everything to my kid outright and let them go, let an 18-year-old run wild with it, put it into trust for their benefit so that they can have some guardrails on it. And then it names fiduciaries. So the people in charge of getting everything from point A to point B, guardians for minor children. We'll talk more about that a little bit later. And then trustees. So if I set up a trust for somebody, I might say, well, my brother is going to be the trustee of it and make sure everything is properly managed up until my kids reach a certain age, for example. When we're drafting wills, we have some special considerations. First, are there special needs? Is there a means tested benefit? Because we wouldn't want to accidentally disqualify somebody from getting those means tested government benefits. Do you have a concern about a minor child inheriting outright? Do I have something specific that I want to go to a specific person? Do I worry about creditors coming in or divorces for my kids, way down the line in the future? Blended families are another big consideration, something that we spend a lot of time with when we have second marriages, especially when there's kids from prior marriages, wanting to make sure, talk about how do we respect the life you had separate and the life that you're building together and reflect that in the document in a way that is going to be the least amount of cumbersome with the most amount of certainty possible for you. And it's kind of on that continuum. Well, those are types of things that we address in a will or a trust. If you don't have a will, though, you die what's called intestate. The state of Maryland is kind enough to have written a will for you, and it may say exactly what you want. It may be completely antithetical to what you want to have happen. Oftentimes, it makes some amount of sense. It goes to some combination of spouses, children, parents. Sometimes it does get a little wonky, though, especially if you're going further out. Um, you don't have control over it. You also can't name the fiduciaries, those decision makers. Whereas if you have a will, you're picking who your personal representative is. Otherwise, it's somebody petitioning to be a personal representative based on the order that's outlined in the statute. And yeah, it's adds time, adds expense, and can add complications too. So if something passes either through your will or through intestacy, that's going through the probate process. Talk a little bit about that. Probate's just the court making sure the instructions in your will get carried out, or if you don't have a will, the intestacy statute making sure that everything flows according to that. It also is there to validate a will. If there's people who are fighting over which will is the last will and testament, the court's there to sort that out. It's there to enforce the right of creditors. If I owed somebody money and they want to get their money from my estate, there's a process for filing a claim. And it's just ensuring that orderly transition from point A to point B. A lot of times in Maryland, it's supervised by an office that each county has called the Register of Wills. That's if things are going through administrative probate. Uh, Sometimes it will go through judicial probate, which is the courts stepping in themselves. I'll refer to the register as the courts because they're kind of using that function. But it's the county government agency. They are supervising the process. And all things considered, Maryland is a pretty good state for probate. There are a lot of states where it is a lot more cumbersome, a lot more expensive, and time consuming. Some states you need to have a lawyer involved. In Maryland, especially if you're doing things administratively, you can oftentimes do it without a lawyer, although we're happy to help. We're happy to step in if you're unsure and need additional assistance. I'll mention quickly where probate happens. Probate happens in two places. It happens where you are domiciled and wherever you own real property. So if I'm domiciled in Maryland and I've got that beach house in Florida and I pass away, I've got to deal with Maryland probate, but then I also have to deal with Florida probate. So when we talk about probate and probate avoidance, one of those considerations is, well, am I going to be subject to just Maryland probate or probate in a bunch of different places? So avoiding probate is something that we talk about a lot with clients. Revocable trusts are one of the big tools we use. And if you think back to those four buckets, those four ways property passes at death, there's the joint titling, there's beneficiary designations, there's trusts, and then there's everything else. We're trying to get, if we're working on avoiding probate, we are trying to get everything out of that fourth bucket and into buckets 1, 2, or 3. And oftentimes the bucket that makes the most sense are revocable trusts. They're essentially a will substitute. They're something you set up now. You're the trustee, you're the beneficiary, you're the person calling all the shots. Like the name suggests, it's revocable, so you can revoke it, amend it, change it at any time. It's really just there to be a bucket to hold assets so that if Chris dies, Chris doesn't own the property in the trust does. And since it's not in that fourth bucket, it doesn't go through probate. It goes based on the instructions in the trust. No tax benefits or anything like that. It's just avoiding that probate process. We don't recommend trusts for everybody because they're more expensive to set up. They're a little more cumbersome to maintain, and they take a little more legwork to get the ball rolling. But they're useful for a couple of reasons. One is privacy. Um, Anything that goes through probate is public record. If you don't want something being part of the public record, then having it owned in the trust, it's a private process instead of somebody can go down to the courthouse and request a copy of that valuation you had to do of your privately owned business, for example. Um, Disability imminent. So if I know, my parent is aging, they aren't making all the best decisions anymore. Powers of attorney can still be kind of cumbersome to implement if assets are owned in a trust. Well, the trust is still the owner, it's just the successor trustee, me helping out my parents, who can come in and manage things. And oftentimes that's a little bit easier to work with than implementing a power of attorney everywhere. Real estate in multiple jurisdictions. So, like I was saying, that example of I've got the Florida house or the condo at Bethany or whatever, and I want to avoid probate both in Maryland and Delaware, Florida, wherever, then I'm going to consider having a revocable trust to hold all of my property so that it all avoids probate. Closely held business interests are another one where just it kind of goes back to the privacy piece and just not involving the government in the transition of your business where maybe there's some other snags that can come up. And then lastly is probate fees. So probate, it used to be sort of flat fee wise, but they changed the fee structure a couple of years ago to make it more progressive. Um, it's small numbers when compared to the totality of everything that's passing through probate, but it starts adding up to some real dollars and cents when you've got a lot going through probate. So where it used to not make a lot of not a huge difference financially if you were, the difference between a will plan and a trust plan versus the savings and probate fees for big estates used to not be a big delta. Now it is, so it's part of the cost consideration. We talked about the trust bucket. Joint titling and beneficiary designations are other tools that we use. It's something, though, you want to be deliberate about. Um, with first marriages, it's very common to have all of your assets jointly titled or beneficiary designated to each other. The backup, so the contingents, that's where people can get into trouble. Um, like, for example, I hear, I'm just going to put my kid's name on a house. Well, that sounds good in theory, but you're potentially losing a step up in cost basis, which can sort of feel questions about later, but that's an important income tax consideration. So there might be some income tax consequences. Uh, you might be opening up that house to the claims of your kid's creditors. So, if your kid's driving around the Beltway, runs a bunch of school children off the road, gets sued for mega millions of dollars, now all of a sudden that house that you titled jointly with them is subject to the claims of your kid's creditors potentially. So just some things where it sounds convenient, but there might be better ways to get stuff from point A to point B, and it's something to do in conjunction with an attorney if you're making big decisions like that. Same thing with beneficiary designations. Uh, you just want to be very deliberate about the wording on them to make sure that they coordinate with your plan. So that's the very basics of what an estate plan is. Want to talk about how to make an estate plan now. So got some options. You can do it yourself. You can do online forms, or you can go to an estate planning attorney. You can probably guess what my recommendation is, but the DIY and online forms, they they can often be worse than nothing. Um, we see a lot of them, and we see a lot of them in the probate context. And we've had some real disaster scenarios. For example, I had one where the will said, the DIY will said, I'm leaving my life insurance policy to my kids. The life insurance policy was still beneficiary designated to ex-wife, and it was the main asset, and the ex-wife was not the mother of the kids. Well, $1.2 million went to the ex-wife, and the the children were left with, still something, but much smaller amount altogether. Luckily, we were able to work something out in the situation, but it was something that decent planning would have addressed. And it's also something where if you're looking at it and you're doing DIY, yeah, it said in my will that I want it to go to my, 3 kids. Why wouldn't that happen? It's one of those you don't know what you don't know type of things. Um, you've got, for example, access to digital assets. These are some boilerplate provisions that we put in a lot of documents, and we update our boilerplate as the law changes. Um, a lot of the DIY forms or online forms miss stuff like that, and getting into digital accounts, unless there's a specific authorization in the will, you have to petition the court, and it just becomes a thing. There's also inconsistent instructions. It's you want to be precise when you're doing these documents, and sometimes people accidentally give something away twice or are unclear with what they're saying. And even though it makes perfect sense and maybe even kind of colloquial sense when you're writing it down, it's something to fight about. So the recommendation is go to an estate planning attorney. We'll be up to date on changes in the laws. We'll be able to customize the document to your situation and to know what the customizations mean. It's one of those things where I'm sure everybody here is an expert in what they do, and we're an expert in what we do, and you probably wouldn't trust me to do your job. So it's even though it might be saving some expense and the front end, it can really lead to some disastrous results on the back end. Also, malpractice insurance, if we screw up, there are consequences to us. My law license is on the line, so I'm going to take your documents very seriously. If you do choose to work with an estate planning attorney, sort of give you an idea of what to expect, what the process is. I'm speaking from my experience, from the experience with my colleagues. So your mileage may vary, but this is typically what the process is like. Initial meeting. Some attorneys do free consults. We charge for our consultations. We'll do a 15-minute getting to know you call beforehand without a charge, just to um, uh, make sure you're comfortable with us and explain how we work. But if we're sitting down and we're sort of working on your plan, we're doing some work for you, and we'll charge for that consultation. We often ask for information prior to the meeting so we can have a productive first conversation and not waste either of our time when we're sitting down to meet. Oftentimes at that meeting, we will quote a flat fee. I know a big question are fee ranges, and again, it's going to vary based on attorneys, where you're at, your geography, what type of plan you're getting. We're located in Howard County. Our fees start at around $2,000. They can go to, for I'll call it more routine plans, on the exotic end of a routine plan, 5,000, 6,000. I think for basic plans, most of those are in the $2,000 and $3,000 range. There are firms that do it cheaper, less expensively, more economically, however you want to phrase it. There are firms that do it a lot more expensively. So a lot of it's about finding the right fit. And, when we charge for the service, we know our expertise and the work product that you get is, the cost is justified when it's, coming out on the back end. We do share our fees up front. So if, during our sort of initial correspondence, when we send out that intake form, we'll send out our fee schedule so you can have an idea of the ranges to expect. Oh, and if there's a consult fee, that's sort of wrapped into the total fee quote. It's not charged separately. But either way, no matter who you go to, the fee should be open and transparent. We'll do an engagement letter, so we kind of both agree on what the scope of services is, and it's going to vary by firm and the experience of the practitioner, where you are geographically. So we'll sit down, we'll meet, we'll sketch out documents. Sometimes there'll be some open questions. We might have a little bit of correspondence back and forth. We will provide drafts in advance. Our drafts have these explanatory bits throughout, so we try and translate some of the legalese into plain English. I'm not sure every firm does that, but we also, though, don't just say, here's your paper, go have fun. We will always give an opportunity to sit down together. If you just have a couple questions, we'll go through your questions. If you want to sit down and go through line by line, we'll sit down and go through line by line. Then sometimes there's a little bit of back and forth or a couple open issues. Once it's settled, we sign your documents, and that's honestly, those are the easy meetings. The Rest of the work, though, is equally as important. It's following up on beneficiary designations. If we've done a revocable trust plan, do a deed that transfers your property into your trust. We'll work with your financial advisors to make sure that retirement accounts get pointed in the right direction when those are set up. And then we'll follow up with our clients. We schedule it every couple of years, not to say, hey, you need to rush and make changes, but just take your documents off the shelf, make sure that they say what you want them to say, alert you to any big changes in the law, and we sort of go from there. So that's sort of the process. How do you find an estate planning attorney? Well, hello, my name's Chris. Happy to help anybody out. But sort of aside from me being glib there, um, trusted friends and family or advisors, we get a lot of referrals in from financial advisors, accountants, uh, from clients. So it's a lot of people had a good experience and they'll refer to people based on that. Or with advisors, it's somebody that, financial advisor, they know that we worked well with them with updating those beneficiary designations, so they'll send them back to us. Um, Online reviews from trusted sources. Everybody here knows how to Google, so that's a good starting place. But look for somebody experienced and somebody who specializes in estate planning. Red flags, on the other hand, one size fits all. The how I sort of walk through wills versus trusts, that's really something any attorney should be doing with you, regardless of whether you get a will or a revocable trust, and explaining what they are, explaining what the differences are and what makes sense for you. It shouldn't be sort of one size fits all. Everybody's going into a specific plan. Um, there does need to be price transparency. Uh, they should, basic stuff, answer your questions, explain things. The next thing that was big, specialization. Uh, and I'm not saying that it's impossible for some attorneys to specialize in family law and estate planning and tax law and this, that, and the other, but it can be a complex area of law. And if you don't do this and stay on top of this, um, then you're not really doing a service to your clients. So again, being self-serving with this, but look for attorneys that do estate planning. Like that's the core of their job. Follow up that follow up on beneficiary designations and titling, that's a really important part of it. And you want to make sure that your attorney is going to help you with that part of the work. I mean, they're not necessarily going to do every single bit of that for you, but they should at least make sure the instructions are clear and be available to answer questions as you are running into issues. And of course, just trust your gut. Are you getting a good vibe from this person? There are a lot of estate planning attorneys out there, and if something's just not fitting, it's shop around. We're happy to, again, that 15-minute phone call where we're sitting down and just getting a sense of, is this somebody I want to work with? You can normally tell on that 15-minute call if they're going to be responsive to you in the way you should really expect. Now I want to turn to sort of now that we're however many minutes in, the thrust of what this presentation is beyond the basics was special considerations for young professionals and young families. So this might sound like it's going against what I said earlier with needing a will and avoiding probate. For example, when I was talking about my son when he turns 18, he's getting a medical directive and a power of attorney. He's not getting a will because in testacy, he's not going to have a lot of assets. Be a small estate. It's just go back to his parents. It'd be pretty simple, honestly. So he doesn't need one. Oftentimes, a young person might just have a bank account and a 401k. Well, if they put a payable on death beneficiary to their sibling on the bank account and 401k, same thing. That can be all they need in terms of governing how their assets pass at death, and the will might just be belt and suspenders. But if you've got minor children, if you've got accumulating assets, if your beneficiaries are complex, if you have real property, um, didn't add here, but if those defaults, if those intestacy defaults are going to cause big problems, that's when a will might be indicated. This is really for young professionals. I think if you are sort of established, you should have a will, though. Shifting fiduciaries. Young professionals are often the people that you name. Everybody's in a changing stage of life. Your parents, they might be the person or the people that you named in your documents at age 25, but they might not be appropriate at age 40. They might be aging, and your knucklehead sibling who, couldn't get their act together finally has their act together, and they're actually a, you know, productive member of society. I'm looking at you, Nick Walter. That they might be a person that's more appropriate to have in your documents as everybody is aging and getting into a different stage of life. So you, this is a piece that you should re-examine as time goes on every couple of years. Pets. Um, Believe it or not, pets are considered tangible personal property, so they are in the same sort of lump of stuff as automobiles and family pictures and things like that. Oftentimes in a will, we just lump tangible personal property together and we'd say it goes pursuant to any instructions that you might have left behind. At the discretion of your personal representative, something like that. And then you leave a list, you leave special instructions, and that's what goes with your will. And those are the instructions for your personal representative to follow. For some people, that works great. Other people have really specific ideas, especially about pets. And there's a range of options. When we can keep it simple, we encourage people not to add too many complications. But I know for a lot of people, they've got really specific wishes about pets. I mean, you can have pet trusts. You can say, I'm giving, my dog all the stuff that goes with my dog and $10,000 to this person specifically, and that 10,000 is to be used for the care and management of the pet. So just if you want it to be part of the conversation, that's something you should bring into the conversation. Of course, though, children, this is probably the most important thing most families put in their documents is how to deal with young children, what happens with them, and really think through those people you name as guardian. So first, I'm going to separate the finances versus the sort of parental care. The It can be the same person. Oftentimes it is, but sometimes you might say, look, my brother and I, we have the same values. We have the same, he goes to the same church as I do, would raise my kids in the same way. They've got kids around the same age, and that's who I would want taking that parenting role. But I don't trust him to rub two nickels together, and my sister is going to be the person who is going to manage the assets on behalf of my kids. That's when you might say, okay, well, I'm leaving assets in trust for my kids, and my sister is the trustee. And then my brother is going to be the guardian and deals with the parenting role, and they'll have to have some level of coordination. But when you're doing all this, think through the relationships, how, obviously the relationships are going to change, but, think how would my brother be as their parent? Do I name my brother and my sister-in-law or just my brother? And there's implications to both of those that your attorney should help walk you through. Um, Oftentimes we'll name both, but we'll say in the event of divorce, it's just my brother or just my sister-in-law. I've seen that too. This is just a quirk in Maryland law for first children, well, it's most often for first children, but if I make a will and then I get married and then I have a child, my will becomes invalid. If I do that in any other order, then my will is valid. So just throwing that out there. If you did a will a while ago, then you got married, then you had a kid, um, your will was revoked just by operation of law. So just might want to go and make sure that you have a valid will like you think you do. Special considerations for retirement accounts. Wills often account for after-born children already. They account, we're going through all the what ifs. We're saying, well, if you have more kids, it'll go to the kids in equal shares. If a child, God forbid, predeceases you, it would go to their kids, if any, otherwise to their sibling. So wills normally take care of that, and same with trusts. Beneficiary designations, not always the case. So if you have a new child, look at your beneficiary designations and make sure that they're updated to have everything going where it's supposed to go. And don't forget about old 401ks. You can roll those over into an IRA, and having everything consolidated in one place means you're not having to remember, okay, well, now I've got to update the beneficiaries here, and there's this like $3,000 thing from when I had that job for 8 months back when I was 24, and what to do with that, because it's those like little dribs and drabs that can be huge administrative headaches. 529 plans. This is sort of getting in the financial advicey territory, which is not what we do, but it's good to talk about and throw out there. It's a popular college planning tool. These are essentially accounts that you set up that grow tax-free. And if you use the uh, assets in that account for a qualifying educational expense for a beneficiary, then it comes out tax-free too. So it's pretty significant uh, tax benefit that we have to incentivize saving for college. Um, if you have excess in the account or beneficiaries change, you can update it to a new family member. Anybody can contribute to it. We will sort of make part of our checklist, though, if you're the custodian of a 529 account, I'm the parent, I set it up, make sure that I've got a successor custodian. So if something happens to me, there's a backup in place that it just transitions to. Organizing information. Um, Digital assets, passwords, access, different ways to do it. I use a password vault. I think it can be a useful thing to do since passwords change all the time. Not having a piece of paper where I write it down, I use Bitwarden, but there's all sorts of services out there. I'm not endorsing it, but you can look around and find what works for you, where it'll manage all of my passwords as they update. It'll update them. There's a master password that gets me into everything with like 17-factor authentication, but there's sort of a dead man switch on there where if my designated people request access and I don't deny them access within a time period, they'll get all of my passwords. That can really ease transition to having somebody else step in and help them manage things for you, either during death or disability. I also have an open if dead document that has all the specific instructions for different accounts. Here's who you talk to for this one. Here's how this one's titled. So a good document to compile and perhaps keep with your estate planning documents just as a guide. Debt. Couple types of debt. So secured debt. So that's like a mortgage on a house. If I die and there's a mortgage associated with a house or a car loan or something like that, well, it's enforceable against that asset. My lender can still foreclose on the house, for example, if nobody's making the payments. They'll often work with an estate, but it's out there. Unsecured debt that's in my name alone, though, that's only enforceable against my estate. So my creditor, if they want to get paid for medical debt, for credit card bills, etc., nobody else is on the hook for them automatically. They need to file a claim against my estate, and then they can duke it out with my personal representative, whether it's a valid claim. So if somebody passes and you got creditors asking you to kick in and pay their debts, talk to the attorney handling the estate and help them, have them help assess whether it's something that you should be paying or not. Joint debt, It's often enforceable against both parties. So if me and a spouse both took a loan together, oftentimes we're jointly and severally liable for that debt. So then it could be enforced against me if a spouse predeceased. And then student loan debt, best thing you can do with that is pass away because it's discharged to death. So that is not legal advice. Please don't do that. But just to have in the background that it's not something that's going to be passed on to family members like other types of debt might be. I want to talk about parents' estate planning. If you're a young professional and you have parents that are aging, uh, you know, your parents either should be having these conversations or might have already had these conversations. You, it's going to be relationship dependent on what, if anything, is shared with you. It's their plan. But if you can, get an understanding on if you're going to be asked to step up and to take any role, uh, maybe a conversation with you and your siblings so everybody's on the same page with it. And this is people's feelings can get hurt, and a little bit of sunshine can be a great disinfectant. Uh, and then, like I was talking about with the password thing and the if I die uh, document, making sure your parents' affairs are organized and not just having documents in place, but having some breadcrumbs to get you to all of the information you would need to have. You don't need to have that information right now necessarily, but you need to know where to get it, and it needs to be available to the person who'd be stepping in and taking that role.
Hmm.
Uh, Joint titling. So a lot of young people, we've seen buy a house together before marriage, which sometimes is a great thing, sometimes can, blow up, obviously. Uh, Even if it is a great thing, consider an agreement for what happens if there's a breakup, and just organizing, what gets returned to who, if the house is sold, who gets to stay in the house, kind of like a prenup, but for an unmarried couple, just to have it in writing, and to not have to have that fight while you're already having a lot of other fights potentially. And then if spouses purchase property together, their property has a special character to it. You own it as tenants by the entireties, or T by E on there. It's just like owning it jointly, but uh, it comes with some protection that if one of you gets sued, then anything you own as tenants by the entireties is protected from the claims of your individual creditors. So especially if your house is your big asset, and that's the thing a creditor would go after if you did something to get you sued. Well, that might be an important protection to have. And if you bought it together beforehand, it's just doing a new deed to say we're transferring it from us as joint tenants with the right of survivorship to us as tenants by the entireties. Business succession planning, last one, then we'll get to Q&A. Just if you do own your own business, you want to think through how your business integrates with your estate plan. If you've got multiple people in it, make sure you have a buy, sell, or an operating agreement. We often do estate planning and business succession planning together because in some ways that's what it is. What would happen to your business if you passed away? Would you try, or would your personal representative try and sell it? Would they transition it to a key person to keep it running and then figure out a way to transfer the value back to your estate? Or would you wind it up and just collect the accounts receivable and go about your day? So again, these are just things that need to be part of the conversation if you're a young professional who owns a business. I have been jabbering on. I'm at the end of my presentation. That is a terrible picture of me, but unfortunately, that's what I have. So I'm going to start scrolling through the questions. And I'm going to start at the start at the top and then go down to the most recent. Key reasons to consider a trust. Told by a retirement consultant to consider setting up a trust because I have a lot of beneficiaries. So Trusts, again, this might have been answered during the course of the presentation. Revocable trusts are great probate avoidance tools. It's there to enhance privacy and to take the court out of the probate process. That's their main utility. There are other types of trust, irrevocable trusts, that are often there for tax planning purposes, can sort of beyond the scope of this conversation, something we do a lot of though. So let me know if that didn't get to answering your question. Okay. Is it recommended that two different people for the medical directive, that it be two different people for the medical directive and power of attorney? Can it be the same person? It's often the same person in both roles. It can be different. The coordination that they might have to do is the medical person might order the care, and then the power of attorney might have to, the attorney in fact might have to pay for the care. They're using the principal's assets to pay the hospital bills. Sometimes though, you just might want different people making those two very different types of decisions, in which case, yeah, you'd have two different people. It does make things a little bit more administratively streamlined, though, if it's the same person. Can a Maryland resident serve as power of attorney for a person in another state, Florida? So that's going to be dependent on the laws in each state, but typically, yes, that's you can serve as power of attorney for somebody in a different state. Some states have restrictions on who can serve as personal representative under a will. And whenever you're dealing with trusts, although you can have a foreign person serve as trustee, a non-US citizen, it does make things a lot more complicated. So we are careful about citizenship when it comes specifically to trustees. Property has a TOD on the deed. Would it go to probate? So Maryland does not recognize, and it's kind of a technical distinction, TOD deeds. They do recognize what are called life estates, and that's one of the things I kind of yada through beforehand. Life estates are a deed recorded in land records that says, when I pass, the property goes to X, Y, and Z. So for all intents and purposes, it's COD. That does avoid probate. It can have consequences, certain tax consequences, depending on if it's a life estate where you retain the power to sell or don't retain the power to sell, can have benefits qualification consequences. So that's a bigger answer. Short answer, yes. Big answer, yes, but. How long does it take the probate process from beginning to end? Again, lawyer answer, it depends. Simple probates, 6 months. And the only reason it even takes 6 months is because there's that period where creditors can come in and assert a claim. That period is 6 months from date of death. Once we're past it, we tell the personal representative, yeah, go ahead, unless there's anything outstanding, we can wrap this all up. I've got some probates where there's a state tax, and didn't talk about estate taxes because that's, again, a little outside the scope of the topic, but estate tax is when you've got mega millions of dollars, not necessarily passing through probate, but passing as a result of your death, that uh, you're so wealthy that you owe the government estate tax, and the government likes fighting about how much estate tax you owe them. It can go under audit. That audit can last years. We'll say a typical probate gets resolved within a year. We have probates that go much longer though, and some that go shorter. If you set up a trust and move to a different state, which state's rules apply? Uh, Again, choice of law with trusts is a fun topic. When we do trusts, they are typically governed by Maryland law. There's what laws apply to it, and there's what tax treatment applies to it. If a trust is governed by Maryland law, typically it's governed by Maryland law as interpreted by the Florida judge if there's a Florida dispute, for example. It might be subject to Florida taxation. Whenever you move, and I know this is a pain, and it sounds like the estate attorney's full employment plan right here, but whenever you move to a different state, it's a good idea to, especially for the medical directives and powers of attorney, which are state-specific forms, to have an attorney review and possibly update your plan. Is a timeshare considered owning real property in another state? Oh boy, timeshares. It depends on what type of timeshare it is. If it's just points in a contract that you have with Wyndham, for example, maybe not. If it's a deed, then yeah. Uh, Timeshares are one of the biggest administrative pains with probate. So if you can do some planning around them beforehand, it's a good idea too. Um, but yeah, that's a lot of lawyer answer. It depends here. Um, I have a sibling with special needs and will be dependent on means-dependent benefits for everything. Do I need to consider this in my plan? Uh, yes. So again, big topic. This is keeping SSI, Medicaid, VA benefits. Those are means tested, which means you pretty much have to be at a subsistence poverty level to qualify for a lot of those benefits. Um, if I inherit assets in my name and it brings me over the 2,500 that Maryland allows me to have to still continue to qualify for Medicaid, it kicks me off Medicaid unless I take some other actions. And those other actions, you're losing some flexibility when you are a beneficiary who inherits, because oftentimes you have to put it into a trust that pays back Medicaid for any expenditure that Medicaid has paid for them. Um, Whereas if I set up a trust for a special needs beneficiary and it goes into that trust, it's there for their support, it's there for their supplemental needs, but at their later passing, it goes to whoever I pointed to in my trust. So yes, it's a big topic. I gave it very short shrift, but something you should absolutely be considering.
Chris, I'm sorry to jump in there, but we are like a minute after the hour. So maybe if you could pick like two more questions to answer. I
Sure.
just want to remind everybody that in terms of like if you have special needs, like tomorrow's session would be a great one to attend because we're going to be talking about some of those more esoteric planning issues. And then of course Thursday is about how to have those challenging conversations with family and other loved ones. And then, of course, we have LGBTQ concerns on Friday. Um, so yeah, we're gonna unfortunately have to wrap it up. But if you just want
Sure.
to maybe scroll through and pick a couple of the questions that
Sure.
pertain to the most. Thanks.
No problem. And I'll go quick with this too. Lump of service like LegalZoom under DIY online forums, absolutely. We have a lot of issues with LegalZoom in particular. If I have a beneficiary designated, but that person predeceases me, that person heirs have claims to your benefits. Maybe it depends on what it says in your beneficiary designation. That's a contract between you and the company. It has what ifs built into it. It has defaults built into it. It's going to be very fact specific. What happens when a parent who doesn't have a will and refuses to consider any other options passes? Then their assets, if they're owned in their sole name with no beneficiary, go through the probate process subject to the intestacy laws. It's going, what those laws say are going to depend on if they're married, if the children are all children of the marriage, if there are adult children or minor children. So that's going to depend on the situation. Am I suggesting houses should be titled as T by E? I'm not suggesting anything for specific circumstances here, but it's very typical for married couples to title their property as tenants by their entireties, but there's a lot of caveats to that. How long does it take to get guardianship and POA for an adult with a disability? Guardianship, you can get an emergency order relatively quickly. Power of attorney, that's something you set up beforehand. It takes us a couple weeks to get that done. Typically, but guardianship to really get into the process can take a while. Um, I think I just scrolled through a few, and so if you want, we can wrap it up here.
Yeah, unfortunately, I think we're going to have to end there. As if anything, these I learned so much. This was really helpful. Probably be coming to see you again to refresh my plan because I think some things have changed. But again, to everyone, please come back for the other sessions. I want to thank Chris so much. Thank you all for your attention and staying so engaged. This is a big, important topic. So please take the time to do your plans and don't leave it to chance because there are going to be some unintended consequences and they may create difficulties for the people you love and want to help. So, and for your own self in the case of disability. So, thank you all so much. Hope to see you here, same bat channel, same bat time tomorrow. And again, we'll be sending recordings at the end of the week. So thanks so much. Have a great afternoon.